Okay, guys, so we now have a policy memorandum about what we can expect in the future H-1B filings. Some things are different, some things not so much. What I am going to do is outline what we need to do as a team to make sure that we are taking full advantage of the memorandum's guidelines. Now, many of you who are not on the litigation side may not know that we have extensively litigated. Let me rephrase that. We really haven't litigated because in the last few months, the 8 lawsuits that we have filed, they have all been settled in favor of our clients. So when we prepare our paperwork, as we always do, make sure that we are preparing it for the court, not just for the USCIS filing. With that in mind, I really think that we should continue documenting our cases as best as we can, but yet know what our strong points are. So let me begin by pointing out some of the key ideas that you can remember and incorporate in our future filings as well as RFE responses. First point that you will notice is that this guidance is effective immediately. So it's not that we don't have to wait for a future date. This guidance is effective immediately. And at the very beginning, they say that we are talking about how to determine employer-employee relationship on an ongoing basis, which they are going to interpret as it should be interpreted according to the regulations, the right to hire, fire, etc. Any one of those is a key indicator of employment relationship. You don't have to get into all this nonsense about the right to control and the control issue. So the fact that an employer is hiring, firing, etc., and I'll go over the list with you, that any one of those criterion is sufficient because that list contains a disjunctive or. Okay, so the second part is about the itineraries, which they say we are not going to insist on. So here you will notice that they have a question framed under A1 that should an officer consider an H-1B petitioner and an H-1B beneficiary to have an employer-employee relationship if they meet only one of the hire, pay, fire, supervise, or otherwise control the work factors. And they say, yes, that's the way you should look at it. Now, you should also look at the LCA and any written contracts. So, as we normally do, we go over all the employment contracts, etc., just to make sure that there are no liquidated damages clause provisions that could become a penalty issue. So we'll continue doing that. Nothing changes, but our documentation regarding control does not have to be that extensive any longer. I think we can talk about maybe internally changing our end client letter templates and templates for the vendor, etc. If the positions are for outplacement, there may not be a necessity of a language about actual control. But if we don't have a problem getting those documents, I don't see any reason to change them drastically. But according to the USCIS, any one of those criterion, if they are met, are indicative of an employer-employee relationship. And once again, hire, pay, fire, supervise, or otherwise control. Now, the only thing I would caution is that make sure we don't have any ambiguity in the employment contract. So these things should be clearly spelled out. The question number 2 under the same series is, must the H-1B petitioner establish that employment exists at the time of filing? Remember, we used to have to document extensively, there is a project, etc. The government seems to have softened that stance. They say that a bona fide job offer must exist at the time of the filing. But if you read between the lines, they are saying that the fact that you are filing the case under penalty of perjury and there's an LCA, that itself is sufficient to establish employment without any more extensive documentation. However, that does not absolve the employer from having good faith employment. So for instance, if an employer says that, oh, we'll have in-house employment and goes ahead and signs the paperwork, but they in fact do not have such employment, that is fraud. That's perjury. So what has changed is not the requirement of a good faith job, but what has changed is the documentation of the good faith job. It's a little amusing that USCIS should have to warn on page 3, the highlighted part, the officer should articulate the basis of denying in the H-1B petition. That should be axiomatic. That's the first thing any trained adjudications officer should be looking out for. And we in fact have a lawsuit going into court next week. That's an EB-1A denial, where the order itself is so ridiculously insufficient, there is no way to know what the grounds for denial are. So those kinds of denials are very easily overturnable in courts. And USCIS is basically just reminding their officers, make sure you explain why you're denying a case. The point B about contracts is extremely important. What they're saying here is that if there is an employer-employee, let me rephrase that. If there is a vendor and client sort of chain of relationships, you don't have to document it. But if you document it, they will assess it. So does that mean we should change how we do things? Probably. Because why should we provide documentation that is not required? And in fact, if you present it, you just open the door to more questions. So once again, the question here is, should an officer request the chain of contracts or legal agreements between the H-1B petitioner and the third parties, etc., to assess the employer-employee relationship or non-speculative employment in a specialty occupation? They say it is not required. However, you have to demonstrate eligibility for the benefit sought. Now that is doublespeak. That doesn't really mean anything the way it's phrased. The bottom line is they're saying we're not going to ask for it. We don't think it's required, but the law remains the law. All right, well, that's easy to understand. So what should we do as a practical matter? I would say if the documentation of the chain of contracts is readily available and it is not creating any ambiguities for us, go ahead and submit it. But if the documentation is insufficient, unavailable, I think we can dispense with it. I don't think the USCIS is going to be able to deny the case without at least an RFE. The next point is relatively easy to understand. C1, should we provide evidence of day-to-day work assignments? And the answer is no. And in the same vein, the point 2 underneath this heading says that we don't have to describe our day-to-day job in order to get classified as a specialty occupation. But that does not mean our burden is over. So what does that change for our team? How are we going to do things differently in relation to this idea of documenting the job and describing the job? We'll still describe the job to the best of our ability. And I don't think we've ever been actually asked to describe the job on a day-to-day basis. That's an impossible requirement. We haven't been asked that. So nothing changes as far as our own work is concerned. The next question, question number 3, is, I think, intensely interesting. So what they're saying is, may an officer deny an H-1B extension or change of status or revoke approval if they were benched or never worked but still paid? So they haven't changed the law that there cannot be unpaid benching unless there is a statutory allowance for that. And they go on to talk about what kind of statutes permit us to have benching without pay. So none of that law, the old law, has changed. For example, benching for the convenience of, it's not really benching. If an employee asks for unpaid leave of absence for their convenience and the accommodation is coming from the employer, not related to any job-related reason. So in those cases, benching, or that's not really benching, but time off without pay should be okay. Now, how about those cases where we are paying somebody as an employer, but they are not working? And the answer to that is, the most interesting part is that it shouldn't be for too long. So in other words, if there's a transition between projects and you didn't work for 4 or 5 weeks, that might be okay. But if you're not working for 8 months or 10 months or 12 months, there's definitely a quantitative component that I can see here. But if the lack of employment, and it can never be unpaid unless allowed by law. So that has not changed. The only thing that has changed is that which was always there in the law has been made clear, that benching with pay or non-productive status with pay is okay as long as it doesn't amount to an abuse of the system. So I don't see why any employer would want an employee to sit at home and pay them their salary and benefits. Nevertheless, the government has made it clear, and I'll rephrase and summarize it. You can have non-productive status without pay if a law allows it, or if it is for your employee's convenience, and 3, if it is not too extensive, it's explainable in terms of the circumstances that presented themselves. So what happens if government says, oh no, you had them off work too long? You can never have them off pay, but let's say you had them off work too long. All they can do is find a violation of status and make your employee go outside USA for a visa stamping. But this brings into doubt all these convictions of many people that the government has criminally prosecuted, companies that have been criminally prosecuted for violations of immigration law, which I have testified in court doesn't exist, and many courts have nevertheless gone ahead and convicted employers of immigration violations and fraud where there should be no basis for it because the laws are so vague. And we've been saying it for a long time. How does that change the way we work? Not even a little bit. But just be mindful, if there is an extended leave without pay, or even a little bit of a leave without pay, we have to assess that and make sure we warn our clients that this could become an issue, or it may not be an issue. The itinerary requirement they are not going to insist on, so you don't have to submit that anymore. This is the part that still bothers me about limiting the validity period. One of the lawsuits we settled with the government last week involved a situation like this. Some of you are aware of this litigation, some of you in our team are not. So basically what happened was they gave our client an approval for a duration less than what we had asked for, much less. And they informed us about the shortened approval after the approval had already expired, thereby putting him out of status for 43 days. Within 5 days of receiving that abbreviated approval, we filed for an extension again. We got the extension, but without the I-94 saying, oh, you're out of status. But who put us out of status? You did. So fortunately, when that case, we had filed that case and we were going to file a motion for temporary injunction, interim injunction, or what is called stay, the government decided to reconsider their position. We've got the I-94 and it covers the entire period there is no gap in his status. But it's just something to be careful about. We don't really want to go court over things, but if we have to, that option is always there. So what they are saying to their officers is that you can still limit the validity period, but it must be accompanied by a brief explanation. Oh, I don't like that term at all. The phrase brief explanation, it's just so ridiculous. I can expect this to be abused quite a bit by the USCIS. However, I am pretty sure after a few litigations that will straighten out too. Okay, so that's pretty much the way it is. We have a little bit more latitude in some things. We should still document the case extensively as if we are preparing for court, and we should be mindful of things like an extended leave of absence. If you have any questions, guys, just reach out.